it was good to its guarantee because it said that, look, I have guaranteed it. You come through this scheme, yes, initially 4,000 rupees per day. That's all right. That was just in terms of the mechanics. But my guarantee remains intact. So please recall that the guarantee remained throughout, right till the statute, which we will deal with subsequently. So that concept remained. Now, supposing there were no statute, the 2017 Act, 2016 Ordinance. If there were no statute, the guarantee would have remained.
Continued.
It would have continued. The guarantee would have continued, which would have meant, sorry. Yes.
Every bank note of a denomination other than 1 rupee
Right.
contains a promise by the RBI.
Right.
The guarantee is by the government. The guarantee is by the government.
Correct.
The promisor is the RBI.
Correct.
That is how we have to look at it. If the promisor is the RBI and the guarantor is the central government,
Yeah.
once the primary liability, you will have to go back to the Contract Act because it is also a negotiable instrument.
Right.
Therefore, the liability of the guarantor is coextensive with that of the promisor.
Yeah, I agree with you.
Therefore,
That's possible in most situations.
yes.
So we'll come to that. That's the 34 point. Your Lordship is as usual far ahead of me. I'm going a little slowly. The point I'm making now is, I'm suggesting a situation where there was no act at all. I'm just suggesting to the court what would have happened. What would have happened is, now I'm answering your Lordship's question, that say on the 1st of January 2017 or on the 10th of January 2017, the government of India would still be liable in terms of the guarantee. And as your Lordship correctly said, the Reserve Bank of India would still be liable under 34. So you would have had a slew of writ petitions and suits by parties who could not exchange, saying that now I'm enforcing a statutory guarantee and I'm enforcing a statutory liability. In a hypothetical situation where the act did not come into force. But I am emphasizing this because there are distinct legal concepts. There is one legal concept of legal tender. There's another legal concept of central government guarantee. And there is no provision. Now we come to the next stage. There's no provision under the RBI Act itself by which you can extinguish 26(1) and you can extinguish 34. 26(1) liability of the government as a guarantor is a statutory liability. The only way that can be undone is by either another statute or if you have some provision in the RBI Act itself by which they can by notification or otherwise negate 26(1). There is no such latter position. So the only way the government could have extinguished its liability is through a statutory provision which is a separate whole area of operation, extinguishing the central government guarantee under 26(1). Now just go to 34. Go to 34. Now this is slightly different. It's not in conflict with what Mr. Chidambaram said, but it's a nuance, I hope.
But,
yes, I'm sorry.
Even 26(1) and 2 will have to be read together.
We'll come.
When 26(2)
Yes.
provide that it empowers the central government
Yeah.
to issue a notification
Yeah.
that from a particular date,
Correct.
any series of the bank notes
Yes.
shall cease to be a legal tender.
Correct.
So once they cease to be a legal tender,
Yeah.
then how can the guarantee survive?
Of course it survives. It definitely survives. Now this is a very, very important point.
No.
First and foremost, I agree with the court. Sorry.
No, let us read 26(1) again.
Yes, I'll read again. I'll read it slowly. Subject to the provisions of subsection 2, every banknote shall be legal tender at any place in India in payment or on account for the amount expressed therein and shall be guaranteed by the central government. May I also read two?
Once it ceases to be a legal tender,
Yes.
how can the guarantee still survive?
Correct. So now that's very important. So this is a very, very important point. Legal tender is both between citizens to each other, because you see the concept at any place in India. So at any place in India, two citizens exchange for value is legal tender, and it's backed by the act, etc. So to a completely private transaction which has nothing to do with the government of India, it is legal tender. Now, who backs it and supports it, and what gives you value and assurance for that? The central government guarantee. So now let me just give you a very simple example. Supposing we had a handful of, I don't know, 10,000 rupee notes. Your lordship saw that in the earlier demonetization, right? 10,000 rupee notes, barely in circulation, etc. Hardly in circulation. But for one of the reasons which Mr. Chidambaram suggested, they are old notes, they've got crumpled, etc., etc. The government of India, it's some minute fraction of the currency in circulation. And the government of India says that, look, we are getting rid of this. No longer legal tender. Right? A recommendation is made by the Reserve Bank of India in the proper order. It said that, look, there are 100 or 500 of these notes. We are not having it. So they issue, on the recommendation of the Reserve Bank of India, the government of India issues a notification under 26.2, which is the mechanics as far as 26.1 is concerned. Now the question put to me is, it seems to be legal tender. Doesn't the guarantee automatically disappear? That's your lordship's question. My respectful submission is no. In the hypothetical situation which I have given you, the central government or parliament may say, or the government will say, we don't need to extinguish central government liability. Because look, there are 500 such notes which are in circulation across the country. Whenever they come to the Reserve Bank of India counter, we will exchange it. 1 year from now, 10 years from now, 25 years from now. The guarantee of the central government has remained, and in discharge of its obligations as a guarantor, 5 years from now of that notional date, we will accept the note because the guarantee is alive. The guarantee has a corresponding duty. If you go to a writ court or you file a suit, the government of India will be duty bound to honor that commitment. So please, my lords, it's a distinct concept. Legal tender is in inter partes, all inter partes transactions, whether or not involving the central government. It may be private parties, it may be a private party and a state government, it may be private parties and the central government. All those where it is exchanged, it shall be legal tender, or as your lordship says, the medium of exchange, etc. of the specified. But guarantee conceptually is completely different. So to answer the question, in my respectful understanding, these are distinct concepts and there is no automatic extinguishment. I think Justice Gawai's question to me was that, is there an automatic extinguishment? The answer according to me is no. Now I'll give you another reason why. It cannot be that a subordinate action or an administrative and executive action robs a legislative guarantee furnished or assured under 26.1. That's another way of looking at it. It ought not to be. 26.1 is a statutory guarantee in terms of a parliamentary statute. That cannot be diminished by an executive action, howsoever wholesome it might be. It has to, as a matter of law, be extinguished by Parliament or by the legislature.
That is why the 2017 Act was...
Absolutely. So that's the point. And that's exactly the point.
Your argument will not hold good.
It will hold good. Let us see. Let us get
Yes,
the
yes.
contract.
See, once the promise gets extinguished,
Yeah.
the guarantee also gets extinguished.
The promise doesn't get extinguished.
No, the legal tender. See, the bank note, once it is no longer a legal tender, that why it is intricacy between the citizens, why it is a legal tender, because it carries with it inherently the promise to pay.
Yes.
Once that promise to pay goes, it's like you imagine the case of a promissory note given in favor of somebody or bearer.
Correct.
So it becomes a negotiable instrument that
Yeah.
not restricted by any crossing. Okay, not restricted by any endorsement. If it is not restricted by an endorsement, the promise, once the promise vanishes, the guarantee will vanish under law of contracts.
Okay, two answers to that. Answer one, what your lordship is putting to me is actually statutorily captured by 34. Now go to 34. There is no notification under 34. The 34 is the point. The liabilities of the issue department, your lordship will recall, is defined in section 23.
Yes.
I am now on 34. Separate section altogether on Reserve Bank of India liability. So not the guarantor's liability, but the question your lordship is putting to me, promise to pay. The liabilities of the issue department shall be an amount equal to the total amount of the currency notes of the government of India and bank notes for the time being in circulation. This is a distinct liability, nothing to do with the central government. This is the liability conceptually of the Reserve Bank of India. Sorry.
34 argument is different from your first argument. We are
I agree.
talking about the
It
first
is.
argument.
You're right. I agree. So my suggestion is, now let me just meet the points which your lordships have put to me. The question is, will a guarantor continue to remain liable if the primary or the principal, whatever, the promisor, or the promisor is discharged? That's the question. Now let me tell your lordships, there are two levels of argument. The first is, this scheme departs to the extent that it does because it's a statutory scheme. So you're right that as far as the general contract law is concerned, there may be. But we have two special provisions. One is 26, which statutorily says that and shall be guaranteed by the central government. So that and shall be guaranteed is a statutory liability imposed on the central government. One. The second is that this statutory liability, even if the note disappears, even if the note is no longer legal currency, will still remain. Because what's the point of the guarantor? So let's take an example.
26(1) contains two components, as you rightly believe.
I believe so.
We are agreeing with you. The first component is that it is a legal tender.
Correct.
And the next component, there is a conjunction and.
Yes.
So long as it is a legal tender and it is guaranteed. That is how you have to read it.
But I think, I'll tell your lordships why that may not be, that's not the understanding of the government. I mean, but that doesn't mean we can both be
It
wrong.
was never argued. So
No, we can both be wrong.
you are saying that is not the.
So in internet
The
also,
government did not have an opportunity to answer this. So where is the question of government?
No, they have answered it. The reason I am rejoining to this is because the answers.
No, this submission is
Just a second.
This submission is coming for the first time.
No, it's not coming for the first time, my lords. Can you just sit down now or go on?
Mr. Diwan,
Yeah.
this submission that even if it's this to be a legal tender, still it is guaranteed, is coming for the first time in the rejoinder.
It is not, my lords. It is.
I'm sorry,
I have made the-
I'm sorry because all of us have taken elaborate notes.
Anyway, I realized.
We are not stopping you to make that
Yeah,
argument.
very well. I'm grateful.
My objection is only to the statement that the government has not replied to it.
No, okay, very well. So, Manoj, I'll deal with it. Sir.
The government did not have an opportunity to
Please give them whatever opportunity is required. And I'm going to place the government stand on this aspect also very shortly. That is why I requested that the Attorney General submissions be placed. So first and foremost, so now let me just answer Justice Ramasubramanian's point. The issue which is now being raised is that look, and shall be guaranteed by the central government must be or ought to be read as coextensive with so long as it is legal tender. That's a possible
That's
view.
the prima facie.
Yes, prima facie view. Now, I would respectfully submit that I would suggest to the court that please depart from this. Why? Please consider or revisit your prima facie view. Now, why am I suggesting that? The reason I am suggesting that is that ordinarily a statutory notification by an executive authority, if you agree with me, of course, your lordship may say that this is 26(2) is also legislative in nature. That's a separate issue. If it is an executive function under our schema cannot override and trump a legislative mandate provided by Parliament. So if you have a legislative mandate shall be guaranteed by the central government, it shall remain so. One. Number two, Parliament so understood. How did it understand? It understood it in the manner I am submitting. Parliament, not only in the past in 78, etc., but even now, has so understood that the 26(1) liability continues to subsist and has to be extinguished by statute. That, as your Lordship correctly put to me, was the necessity for bringing in the 2016 ordinance / 2017 Act, one and the same thing. So what you have is a situation where I would respectfully submit, statutorily, the central government's liability guarantee lingers beyond the extinguishment in terms of a notification under 26(2). And number two, there is no necessity for an extinguishment under 26(1) by statute, because you could theoretically have situations where the impact is so minor for some notes which are still left in currency, etc., that the central government says that I am going to continue with my guarantee. Why should I? It's after all a sovereign guarantee. A person comes 3 years down the line or 5 years down the line for a 10,000 rupee note or a 1 lakh rupee note, I don't have a problem. So there's no automatic extinguishment. Yes, I'm sorry.
That is actually,
Yeah.
as Mr. Chidambaram pointed out,
Yeah.
though we call it demonetization,
Yeah.
it is always followed by remonetization.
That's the
Therefore,
physical element.
That is how the permission to exchange the
Yeah.
demonetized currency is on account of the remonetization. Therefore, it is not as though the primary liability vanished, but the guarantee continued. Therefore, their exchanging is not the question. It was because of the remonetization that, in fact, the internet we have considered that this currency is actually a negotiable instrument.
It is.
Therefore, if it is a negotiable instrument which can be
But superadded provisions of statute, the Reserve Bank of India Act,
34 stands on a different footing. But 26(1) you are reading, we are not.
anyway, so now, your Lordships have followed my
But
point.
in any case,
Another
Yeah.
way,
in any case, on 30th of December 2016, it is that guarantee extinguished.
Correct, so that supports me, so I'm coming to that. The point I'm making just now is, let us understand the statute. There are distinct concepts, your Lordships may accept, reject, that's up to the court. There are distinct concepts of legal tender, there's a distinct concept of central government guarantee, and there is a process under 26(2), and I have made my submission that a positive recommendation by the Reserve Bank of India is a condition precedent for the purpose of exercise of 26(2).
No,
Now I have 2 minutes.
that is
Sorry.
also agreed by Mr. Gupta that there are two requirements
Right.
under section 26(2),
Recommendation.
recommendation and decision.
Decision. Yes, correct. And if both, but if there is no sorry.
So there doesn't appear to be a quarrel on that there has to be a twin requirement under section 26(2).
No, I'm not suggesting. I think a specific question was put to us that absent a recommendation, your Lordship was obviously contemplating all sorts of situations. So I'm just putting it down in the simplest manner in which I can, that a positive recommendation by the central board on our understanding of the law is a condition precedent for 26(2). The reason I'm making this answer and putting it in plain terms is there was a lot of submissions, there were a large number of submissions made, monetary policy, fiscal policy, integrity of India, this, that, and the other. Maybe you can do it. Now, let me just answer that issue squarely. This does not mean that Parliament or the executive through an ordinance route is robbed of the power in an exigency of waiting for that central board to make a recommendation. No. The administrative route under 26(2) is not available. The ordinance route or the parliamentary route for the purposes of abolishing may always be available in an exigency. Please understand, my submission is 26(2) is purely administrative action. Purely administrative action, 2 stages. Positive recommendation, action by the central government. Even a positive recommendation by the Reserve Bank of India may be rejected by the central government, and they may say, sorry, nothing doing, we don't approve of this. Your own Reserve Bank of India governors in the past have said this is a worthless measure, we are rejecting it. Fair enough, that can be done. But that doesn't mean Parliament is helpless or government is helpless. In an exigency, they have recourse to the legislative route, which can be either through a parliamentary statute or it can be through an emergency ordinance which your Lordships are aware of. Now the last point on 34. 34 therefore is a separate and distinct liability. Now I am reading 26. This is imposing a liability on the issue department of RBI. So therefore I said, but for that act/ordinance, you would have had actions filed against RBI and the government that look, your period is over now. Your period for the purposes of exchange is over. But you still have a live outstanding guarantee and statutory liability. I am therefore suing you on that basis to get rid of that point, which is the legislative liability, not on the basis of legal tender. Legislative obligation, they require the act. So I'll just go to the act in a moment. So the point I am making is the legislation ordinance of 2016/2017 Act was necessary for not to give a cloak or a veneer of legality to 26(2). 26(2) is it operates fully and completely at an administrative. But there were still two things left. What were those two things? Guarantee under 26. One, liability under 34. Two distinct legal concepts. I would